Item 24.
Itu mabuk tu mana kita rensit mana kita kata penuh abu sepuluh. Kita file mana apa lah?
My Lord, in compliance with last order 11/12/23, I have submitted evidence of opposition 5/2/2014, indicating
You filed on
5/2/24, indicating the exact amount of compensation payable to the petitioner at page 6 and 7, my Lord.
1 second. Five two.
5/2/24.
What page?
Page 6 and 7. 6.
So 88 lakhs, Dr. Mozika. Now you agree to pay refund 48 lakhs.
48 lakhs.
We are not agreeing, my lord.
Then on what ground are you, on what premise are you seeking to object to this refund?
My lord, there are 2-3 submissions, my lord, on this.
Yes. 48 lakhs with
Interior staff.
10% interest.
Yes.
6.5% interest, okay.
But I'll just like my submissions, my lord. Basically 2 submissions, my lord.
Okay, who can, we can't shut you down. You are at liberty to make your submissions. Yes. Yes.
In my affidavit, my lord, it's a short affidavit, my lord. Just filed in September 23. Mahfuzur Rahman.
Yes, Mahfuzur Rahman. Yes.
But here, my lord, Annexure A, page 10, my lord.
Lecture?
A, page 10.
Yes.
But this is the report dated 11/12/2017 from the Public Health Laboratory, Guwahati.
Yes.
Next page, my lord, will see betel nut opinion, my lord, the bottom. The samples are damaged, having fungal infestation.
And not suitable for human consumption.
Not suitable for human consumption, my lord. The next page also samples are damaged. It's a type of, my lord.
Who gave this report?
Food analyst to the government of Assam, my lord. But this being a food item, my lord, we sent it for.
These samples are damaged, having fungal infestation, hence are not suitable for
human
use
consumption.
for human consumption.
So, my lord, thereafter what we did, my lord, we informed the next page, my lord, page 12, my lord, so kindly see.
Yes.
This is dated 26 November 2018 to Mr. So-and-so advocate. Please refer to a letter dated so-and-so on the subject cited above. In this connection, the commissioners have observed that since the report of the expert states that the goods are not fit for human consumption, the goods are not to be released provisionally. Because lots of our pending adjudication if the item is perishable, my lord.
So suppose what value can you peg then on these 32 metric tons? Even if infested, whatever is their goods, which has been seized and found to have been illegally seized. Yeah, they will be like they have a right to some claim for some damages and compensation.
Then, my lord.
Fine, okay.
Or page 18, my lord.
They agreeable. The seizure value is 88 lakhs. They said like, okay, we'll accept 48 lakhs.
Well, page 18. Well,
18.
Well,
Okay.
but this is the disposal manual of Customs Department, my lord. This provides for SOP, my lord, what is to be done after seizure, my lord. At page 18, lords will see destruction, 8.11.
Yes.
Commissioner have full powers to order destruction of goods of the following description. Clause C is applicable, my lord. Foodstuffs, spices and other goods which are unfit for human consumption.
Yes.
And one more aspect, my lord, when they applied for, because when we seize, my lord, when the Customs Department seizes any article, my lord, they put a tentative valuation of that, my lord. Because any valuation of any commodity will depend on the quality, my lord. But these are not a fixed market price item, my lord, depending on the quality. Now,
Okay, fine. Whatever it is. Now, what do you do in such cases? Suppose unfit for human consumption, then you can't peg any value. So if your fixation of value is 88 lakhs, correct?
my lord, at page 43, my lord will see. My lord, in fact, from page 42, my lord, last sentence. In his written submission, last three sentences, my lord. In his written submission dated 15/11/2018, Sri Nihar Dasgupta Advocate inter alia requested for provisional release of the seized 32 MT, which would be sold to plywood industry for non-consumptional use, and prayed for reduction of price of damaged betel nuts at rupees 96 per kg, since the report of the expert states that the goods are not fit for human consumption. The goods were not considered to be released provisionally accordingly, so and so. So, my lord, they themselves have put a valuation. My lord, this is my last resort, my lord. Our case is, my lord, we have destroyed the goods in terms of the.
Okay, if 96 1 kilo be how much? Mr. Dasgupta?
Matlab?
If it's 96 rupees a kilo, it'll be how much then for 32 metric tons?
Then it will be added as per circular, duty, penalty, and redemption fine, 300%.
Those
So
those will not be applicable, my lord.
So this is for provisional release, but provisional has not been granted. And circular we have given at annexure 4.
No. What will be the amount? Suppose just the baseline. If it's 96 rupees per kilo,
Yes, my lord. The quantity, my lord, is
32 metric tons. 32 metric, there's two trucks. that means.
32 metric ton. 2 trucks.
16,000 and 16,000. 32,000.
So it'll be how many kilos? 3,200 kilos.
32,000 kilo.
32, yes.
Multiplied by
96. Also how much?
Because, my lord, in this regard, I also want to point out certain provisions of the Food Safety Act, my lord. Food Safety Act.
Yes.
My lord, Food Safety and Standards Act 2006, my lord, section 25.
Yes. That means even there'll be around 28 lakh something.
Well, roughly.
Yes.
Section 25. my lord.
Food Safety and Standards Act,
Yes,
section.
25.
Then we're getting another area now. We're not confined only to, this.
Because, my lord,
If you're going to bring
These
this
are
up
this-
now, that means he's entitled to rebut your submissions also. If you're going to bring the regarding it's unfit for human consumption, and if that's the ground, you deny him the seizure amount. The rule, you want the rule 25.
Section 25. Act.
What is it? What's the act called?
Food Safety and Standards Act 2006.
Food Safety and Standards Act.
Yes, ma'am. Section 25.
It deals with all imports, articles of food to subject to this act.
Well, no person shall import into India
No, now you're going somewhere else.
because the disposal manual takes care of this act. Well, any unsafe or unbranded, misbranded or substandard food or food containing extraneous matter.
So what do you want to show by this?
And
That
this-
even if the importation is legal, they're imported substandard. So what is the what do you call it? The
And
result or the consequence of
consequence is
violation.
Section
violating
67, well,
Section 25.
67. Well.
But they were never prosecuted on this.
Subsection 2 provide any such article of food shall be destroyed or returned to the importer if permitted by the competent authority under so and so, so and so, so. Well, basically, our case is, my lord, we have destroyed, we have not gained any value of it. In fact, we have spent some money on destruction. Well.
So we'll minus the money you spend on destruction, pay them Caesar value.
This is an recognized assessed value. They have assessed, they have confirmed.
You take 29 lakhs plus 10% interest.
I pray to your lordship's
Because see,
wisdom.
you said that fine, we're not going to use it for human consumption. It'll be used for plywood
Private
industry.
industry.
Yes. So fine. So that means at 96 rupees a kilo, it's going to pay 29,000 something and 10% interest for the from 2018.
From 2017, 29/10/2017.
Yes.
The interest, my lord, will kindly, in the facts of the case, my lord. Interest component, my lord. In the facts of the case, my lord, let's kindly appreciate we have not derived any value out of that, my lord.
You'll go and appeal against this order. Naturally. So you can't bring these ground food safety standards
My
act now.
lord, they have accepted
That's
48 lakhs
constitution.
in last order. There should not be less than 14. Now they're again they're submitting
Now
some.
they're going back
some
to your. So you said 96 rupees per kilo, damaged beetle nuts.
That is for provisional list. They have not granted provisional list. We have taken into consideration the additional cost as per circular 16/8/2017 that we have to be added fine, duty and redemption.
I'll hear somebody today, maybe next week. We'll take up that matter. They've been waiting whole day.
Some other day?
Huh? We'll take it already because they've been waiting the whole day for batch matters, nectar.
Well,
Yes. We'll finish that nectar. Because this one's, you have to I'll examine the papers. Otherwise, there are so many judgments that they have to pay the
Yes,
CJ
sir, my
amount.
lord, I have got Supreme Court judgments, so many judgments.
You've supplied.
Yes. All Supreme Court judgments assessable with interest. Now they are denying all these things.
No, they
Everything
cannot
they are
deny,
denying.
Mr. Gupta.
They are denying.
Trying to
They
balance
could
the
not.
equities.
Supreme Court lost in everywhere. Supreme Court they have lost everywhere. They have lost. High Court, Supreme Court, Tribunal. Now they are taking all these pleas after 7 years.
Yes, so sir, paying Rakesh Kumar Sharma. Yes.
Much obliged.
May I please, Your Lordship?
Only one thing that we'll conclude the hearing today.
Yes, sir.
We'll not linger. Dr. Mozika, yes. Yes.
You'll start first? Okay. My lord, there was an advertisement given by Nectar on 10 July 21, which is at Annexure 1, page 30, for filling up sanction post, regular sanction post. And in response to that, the petitioner applied. A duly screening committee was constituted. Then screening committee shortlisted candidates, which is at Annexure 3, page 59.
Okay. Yes.
So these candidates were shortlisted. They were called for personal interview. Entire process of recruitment was followed as per the rules. And after appearing in the personal interview, the candidates were selected. Then call letter for interview was at page 60 is the nomination of members for selection committee. Selection committee was also duly constituted, which is at Annexure 3B, page 60.
I'm trying to refer to your letter number so and so. Post of Chief Radio Technology. These
This
are
is the
posts.
constitution of the selection committee by the competent authorities.
Nomination members for DPC committee for Kurban. Okay. Okay.
Duly constituted selection committee took interview, and thereafter, the offer of appointment was given to the petitioner on 19th January 2022. That is at page 64.
Right then.
At that point of time, this present petitioner was working at Meghalaya Basin Development Corporation. So he resigned from that post in order to join in this new post. His resignation also, I have annexed, Your Lordship. Thereafter, he joined in this new post, and he was working there.
He joined on?
On 19 January 22, on 28th of January only he joined. His service book was also duly prepared. That is at Annexure 9, page 69. His service book is there.
Annexure 9.
Yes.
Annexure 9 is accepting the resignation.
No, Annexure 10 is your, yes, Annexure 9 is your, this is there, the Meghalaya Basin Management Agency, where he resigned and his resignation was accepted. So he resigned from there and after 1st February, and then he joined. Then Annexure 10 is his service book.
Okay.
Yeah. And he was working along with other selected candidates who have also joined. Then suddenly, by Annexure 11, page 73,
Yes.
this letter was issued where his appointment letter was withdrawn, and it was said that the advertisement was null and void.
What
Now,
is Chief Coordinator Technical?
yes.
Okay.
Cancellation of appointment to the post of Chief Coordinator Technical in Nectar.
Okay.
In terms of Para 3 of Service Bylaws of Nectar, appointing authority for post carrying grade pay of rupees 6,600 and above is Governing Council,
In
Nectar.
terms of Para 3 Civil Bylaws, appointed authority, his grade pay is how much?
It is for 7,000 plus.
Okay.
Grade A, it is the appointing authority is a Governing Council. Your appointment letter for the post of Chief Coordinator Technical carrying grade pay of 7,600 was issued by this office letter number dated 19 January 2022. In anticipation of ex post facto approval of Governing Council of Nectar. In anticipation of that, it was issued. However, due to certain representations in the matter, the Administrative Ministry disapproved the recruitment to the Group A post carrying grade pay of rupees 7,600, which consists of your recruitment as well. Accordingly, GC has instructed to scrap the recruitment process and initiate it afresh as early as possible. In view of the decision taken by GC Nectar, advertisement for the post may be considered as null and void.
Okay.
Accordingly, your appointment to the post, void order dated is withdrawn with immediate effect, and your appointment to the post of Chief Coordinator may be treated as cancelled. Your Lordship, the only grant here they have given, they have admitted that it was issued in anticipation of ex post facto approval of the Governing Council.
Yeah.
Now, whether Governing Council has given ex post facto approval. In the 8th General Body meeting, Governing Council meeting, held on 18th April 22. Prior to that, in the 7th General Council meeting,
Where are you reading from?
my lord, if your lordship,
Page?
this is at page, starts from page 82.
Yeah. 8th meeting of the Governing Council.
Yes.
Yes.
If your lordship will kindly turn to page 84 under item number 4. Page 84 under item number 4 at the bottom, my lord.
Status of recruitment
Status
process.
of recruitment process and approval of Governing Council. I may be allowed to read this, your lordship.
Yes.
Chairperson requested to clarify the sub-paras under item number 4 meant solely for information and noting approval of the Governing Council, and the sub-paras pertaining to approval for amendments in RR recruitment rules. DG Nectar briefed the General Council members about the nature of sub-paras under item number 4 of the agenda. Sub-para-wise proceedings under the agenda then progress as hereunder. General Council was apprised about the recruitment process relating to Group A post carrying grade pay of Rs 6,600 and above. The criteria mentioned in the recruitment rules and the role of GC in terms of Rule 3.1 of the Service Bylaws of Nectar for regularization of Group A post carrying grade pay of Rs 6,600 and above was explained in general for seeking approval of General Council. Chairperson asked DG Nectar to clarify whether recruitment rules as approved by the appropriate authority have been followed in the matter. DG Nectar assured the chairperson and all the other GC members that recruitment rules have been scrupulously followed and also the procedure. Selection of candidates has been made by the selection committee interview panel duly approved by the chairman Nectar in a transparent manner. Score sheet of marks awarded by the selection committee duly signed by each member of the committee is available for perusal and records. The scores of each candidate were displayed on the website of Nectar. Not a single representation from any of the candidates has been received in this regard. The offers of appointment were sent to the candidates in order of merit following the precedent adopted by Nectar in recruitment made earlier and approved by General Council as well. Further, the status of recruitment has already been brought to the kind notice of General Council members through circulation via this office letter number so dated 25th February 22 for approval for regularization of these appointments in terms of para 3.1 of the Service Bylaws of Nectar, and as advised by DST via under Secretary AI letter dated 16 March 2022. Executive Council of Nectar has already approved these recruitments during its meeting held on 21st February 2022. It was also informed that approval of 5 General Council members, that is Chief Secretary Meghalaya, Manipur, Nagaland, Sikkim and Secretary NEC, has already been communicated through correspondence. As such, approval of remaining GC members was also sought for in terms of provisions contained under Rule 9 and 10, Part 3 of the General Bylaws. All the General Council members endorsed their approval. Chairperson and desired to place the approval of General Council before Secretary DST being Chairman of Nectar. So in the 8th General Council meeting, all the General Council members duly
all
approved.
the procedures were in
Everything.
proper form.
Yes, my lord. And after that, my lord, surprisingly, in the 9th General Council meeting,
Page?
that is at page 90, item number 1. They have a proper agenda for the meetings. Agendas have been prepared. Item number 1, that agenda was confirmation of the minutes of the 8th meeting of the Governing Council.
Yes.
Here it comes. The minutes of the 8th meeting of the GC were read, confirmed and adopted. So the 8th general...
This is the 8th.
This is the 9th. Okay. In the 9th general body meeting, under item number 1, the minutes of the 8th general body meeting, where all the General Council members' approval is recorded, have given, has been confirmed, read, confirmed and adopted. So item-wise, whatever was the agenda that followed. After that, towards the end, at the end, Under item number 14, page 98, any other item with permission of chair. This matter concludes here, Your Lordship. Here, any other item. So that cannot include confirmation of the meeting.
How come this in 2 lines?
Under this, now they are writing recruitment process update received from Ministry. General Council concurred a decision of Secretary DST on the scrapping.
What's DST?
Department of Science and Technology, Government of India, on the scrapping of the 4 mentioned posts and directed to do the recruitment process afresh following our recruitment rules. Just in 2 lines. Then, pursuant to this, they have. Now, what prompted them to do? This is solely an afterthought with some mala fide intention of some vested interested member or person. Now, Your Lordship, the General Council members are not any ordinary citizen. They are all the chief secretaries of different states. When they are giving their counsel, they are giving their approval in the meeting, they know what they are doing. And it is also recorded that entire process of recruitment was transparent. Selection process, constitution of a selection committee, the scrutiny committee, selection committee, everything was done as per the rules. Now, so we had no other alternative than to approach this Honorable Court for protection. They have filed their affidavit. In their affidavit, basically they are challenging on 2 grounds. Firstly, their contention is that the recruitment rule is not, they are vague about which recruitment rule is violated. There is no such categorical avertments about which particular recruitment rules have been violated. But whatever it is, from their affidavit, what we can see is they are saying that as per the rules, the post should have been advertised, post should have been first filled up through deputation. But they have not done that, direct recruitment they have done. That is wrong. That is against, not contrary to what is available on record. In the advertisement itself, it was clearly mentioned, Your Lordship. At page number, I'll just take Your Lordship's attention. Page 33, if Your Lordship will turn to page 33, this is the advertisement, starts from page 32.
Yes.
Below that table, it is clearly written, Your Lordship, God. All the posts are proposed to be filled up on deputation.
Yes.
Including short-term contract and oblique absorption, failing which by direct recruitment basis.
Yes.
So, meaning that
Either
any
or.
candidate who applies for deputation, if there is a qualified, fit candidate found fit to be appointed, they would have done that. It's not that they have given a goodbye to the recruitment rules to fill up through deputation. It was meant that it will be deputation if no candidate came, failing which it will be through direct recruitment. So obviously it infers that either nobody applied for deputation to be on deputation, or those who have applied were not found qualified or not found fit. That is why they have gone for the direct recruitment. It's not that they have not followed the recruitment rules. Now their second contention was that about the ex post facto approval. And that Your Lordship can see ex post facto.
Now the first ground is say that the recruitment rules were not followed.
They said there was a complaint and an internal committee was constituted. That they have enclosed at the last annexure of their affidavit, my lord. The last annexure of their affidavit, an internal committee was constituted and that committee has recommended. That is at page 27 of their affidavit.
Yes.
An internal committee was constituted under the chairmanship of Sri Sunil Kumar, Joint Secretary DST, with Dr. M. Mohanty, so-and-so, so-and-so. Now, after going through the facts and documents made available, the committee makes the following observation. These are the observations made by the internal committee. In terms of provision as available in the recruitment rules of the post, the method of recruitment was by promotion, failing which by deputation. absorption, failing which by direct recruitment. Instead of first making sincere effort for filling up the post on deputation, vacancies were filled by direct recruitment mode. That is an observation which they fail. Now, rejection of application received by deputation on grounds of NOC, vigilance, clearance, non-availability of APRs does not hold justify, as no efforts were made to get the same from departments, organizations of the candidates. Screening committee has also not recorded any observation reasons for considering the candidates on direct recruitment. Issuing of offer of appointment and letting the candidate assume charge the post without approval of the competent authority governing council is a serious lapse. So these are the only 2 points which the committee has observed.
Yes.
Now, Your Lordship, there is a precedent, earlier precedent is there, where ex post facto approval is taken, given by General Council in the appointment. Earlier also in Nectar itself. And one more thing, what they have stated, ki, it is only with the buyer's intention, only all in-house candidates have been appointed. That is not correct. So far as this particular petitioner is concerned, he was not an employee of Nectar at that point of time. And even in the entire process, in their affidavit also, they are admitting in the affidavit that entire recruitment selection process have been followed meticulously. Selection process, which also includes scrutiny committees, screening, scrutining and selection committee, advertisement, everything duly it was advertised in the newspapers. There is no challenge to all that. That has been scrupulously followed. Now, what is the lapse? Only that they are saying it is deputation. But the advertisement was clearly mentioned on deputation. And why, if there is any applicant was there who did not, who may have applied for on deputation, but maybe there was some technical thing which the screening committee did not do it. But subsequently also, none of the General Council members challenged that. When they were apprised of the selection procedure which was followed, which was adopted, they were happy, they were satisfied, and then they have duly approved. So that was not a defect or lapses. Or
because
now,
you see, one other thing is that in the, what is that, the 9th meeting, whatever, if this was such a serious issue, she will flag the separate agenda to examine, not in any other matters. You confirm the minutes of their meeting, and then on other business. It's not other business, a very serious thing.
And my lord, there one minute, let me just finish. There is one contention that in anticipation of the ex post facto approval taken, that it is not in violation, what is their contention? That it is in violation of the recruitment rules 3.1. I will just take your lordship to the recruitment rules, where it does not talk of any prior approval. If the recruitment rules, if there was a requirement that prior approval of the appointing authority or prior approval, there is nothing. It is only the General Council is the appointing authority. It is only with respect to appointment of the Director General, Chairman of the thing, prior approval of the Ministry is required. But not for A-grade post. It is simply says appointment to the A-grade post will be by the General Council. No prior approval is necessary. And ex post facto approval is given. At best, maximum, your lordship, it can be said to be an irregularity, but not illegal appointment. And Supreme Court is very clear on that irregular appointment can always be regularized, your lordship. And that is not a serious lapse. See that? We had 2 copies now of this service bylaws. Where is another copy? Service bylaws, another copy. This, Your Lordship, I have this service bylaws. This is the only bylaws they have.
General bylaws, this one.
This is the one. Yeah, it is. In the page 2, your Lordship, appointing authority. Page 2, if your Lordship will come, appointing authority.
1 second.
Appointing authority for any post carrying grade pay of 6,600 and above under the centre shall be the governing council. And for any post carrying grade pay below rupees 6,600 shall be the Director General. It is simply saying that. Now, it is a full stop. Next, appointing authority in respect of Director General shall be the governing council with prior approval of the central government. So it is only with respect to the Director General you need prior approval.
Where are you reading?
My lord, is it the same document, not in Northeastern Center for Technology Application and Reach Service Bylaws?
No.
Your Lordship, give that one. This one.
No, that's not here.
This is the one which they are saying it is in violation of Rule 3,
Okay, this one's not here. No.
second page, appointing authority.
Yes.
Appointing authority for any post carrying grade pay of 6,600 and above under the center shall be the governing council. And for any post carrying grade pay below rupees 6,600 shall be the Director General. It is not talking of prior approval of any authority or any board or anything is necessary. And then the next sentence starts, appointing authority in respect of Director General shall be the governing council with prior approval of the central government.
Has this come out in your pleadings?
Yes, my lord. Even in a rejoinder also I've stated. My lord, interestingly, one more thing, by this advertisement was not only for these 4 posts. This was for other posts also. And they are saying the advertisement is null and void. Then what about those who were already appointed who are still continuing pursuant to that particular advertisement? If you're saying the advertisement is null and void, the whole advertisement goes for the other post or the 26 post. And another interesting fact is, by the same way, in grade A post, another person was appointed to the post of, his appointment was, I have enclosed along with my rejoinder, but his appointment was also ex post facto approval by the General Council, but he's been issued a separate appointment letter subsequently, just to regularize him, to protect him, and his appointment has not been cancelled.
Who is he?
He is
Well, what post?
offer of appointment to Dr. Colleen Z. Renthali for the post of Advisor Technical in Nectar on direct recruitment basis. Same advertisement, same selection committee, same scrutiny committee. He is still continuing. His post has not been withdrawn and cancelled. If that advertisement for grade A post goes, this also goes. So this clearly shows the biasness of the authority just to target these 4 persons with some mala fide intention. And except these 2 grounds, they have not taken any other ground, any other pleadings. And in fact, in their affidavit, they clearly admits that entire recruitment process were duly followed. Where is the affidavit? Just now it took me. Their affidavit. In page 6, clause P, they have admitted the notification of list of shortlisted candidates for personal interview for the post of Chief Radio Technologist, Senior Administrative Officer, Chief Coordinator and Software issued. Thereafter, the list of shortlisted candidates to be called for personal interview for the above-mentioned post on the website was published as per government norms. Screening committee, selection committee, etc. for appointment to the advertised post was constituted with the approval of the appointing authority for the post. Personal interviews were conducted by the approved selection committee for all the 4 posts as per norms. So they admit that everything was as per norms. But here they are also taking another ground. Somewhere they have taken it during the hearing or in the affidavit that one of the candidate, I think represented by my friend, that he is a candidate appointed and he was also in the scrutiny screening committee. So he was an employee of Nectar. He was working on contractual basis, I think. But it was only during the screening committee. They have to take help. It's a newly established department where they have very few employees. So those who are at that time working, he was only screening the applications. I don't think by that he has influenced or anything that can be a big lapse or anything so far as that particular candidate is concerned. So, but so far as this
No,
candidate,
the screening committee, that means if you're to be disqualified, be others, be under this,
Yeah.
another consideration.
that is
be
only
not-
to
not qualified.
check the applications, whether everything is in order or not, that's all. Initial screening committee. That is it. So this is my humble submission, Your Lordship, that this is nothing but totally arbitrary and illegal action on the part of the respondents.
He attributing malafide also, he said.
Yes, Malafide.
He made the person by name. No.
It won't be proper to be by name, Your Lordship.
Malafide always by name. Anyway,
But
yes.
their action clearly shows that it is Malafide, and I also rely on two judgments of the Honorable Supreme Court.
Yes.
Basically, one on this point, that at best
Just give
the
citation.
grounds that they have taken, that can be termed as an irregular for ex post facto approval, can be irregular, which can be always be regularized. I'll supply a copy, Your Lordship. This is Supreme Court of India, and Civil Appeal number 392 of
Neutral
2004.
neutral
I don't have the
citation.
citation. I've taken down
Is it
from.
neutral citation?
The citation
No,
is
is it
not
neutral
there.
citation or now the the neutral citations come out.
You can just give a copy of this one.
Because now they want to finish up the prohibitions. No, it's not neutral citation. It's not.
Irregular and illegal appointment. This one also.
This is Patnaik's judgment.
This is not part my margin, friend. If something comes up, then I will reserve to address.
Mr. Paul, anything to add or same?
Just two small issues.
Yes.
Both are different. Well, as I have a small list of dates here, insofar as the petitioner is concerned, my lords, this is in WPC number 430 of 2022.
430.
Of 2022. List of dates. Well, it's here I was my lords, appointed as the chief radio technologist. And I was serving already, my lords, I was serving in the same body as a project officer in Nectar itself. Rest of the dates are more or less the same, my lords. We're placing reliance on the same issues. But one aspect of the matter, my lords, that I thought should be brought to your lordship's kind notice. Well, I'll take your lordships to the impugned letter that has been sent to us so far as
You are concerned.
lordships. Lordships will find that at page 156.
One
156. That's the email that comes to us, my lords, informing us that the selection process has been undone. Your lordships have.
Yes.
Lords, if I may read, in subject cancellation of appointment to the post of chief radio technologist in Nectar. In terms of para 3 of the service bylaws of Nectar, appointing authority for the post carrying grade pay of rupees 6,600 and above is the governing council, that is Nectar. Your appointment letter for the post of chief radio technologist carrying grade pay of 7,600 was issued by this office number so and so, dated so and so, in anticipation of ex post facto approval of the governing council of Nectar. However, due to certain representations in the matter, your lordships may kindly take note of this expression. However, due to certain representations in the matter, the administrative ministry disapproved the recruitments of Group A post carrying so and so and above consist of your recruitment as well. Accordingly, GC has instructed to scrap the recruitment process and initiate it afresh early. Now, I'll take your lordships back to the minutes of the 8th meeting. Your lordships would find that at page 142.
One.
142, my lords.
Yes.
And this is dated 18/4/2022, my lords. So, if your lordships kindly have 2, 3, 4, fourth paragraph, my lords, the last line. Lordships have it, my lords.
All the GC members endorse.
No. My lords, fourth paragraph from the beginning, my lords, from the top.
Okay.
It starts with DG Nectar.
Yes, yes.
And the last line, your Lordships will kindly see, not a single representation from any of the candidates has been received in this regard.
Yes.
So, my lords, in the letter that is informed to me, we are informed that there is some kind of representation as a result of which the selection process is scrapped. Now, in the counter affidavit filed by them, my lords, they have annexed the minutes of the internal committee, which your Lordships would kindly please to see. The Lordships would find it at page 28 of the counter affidavit in this matter, my lords. Counter affidavit is the
Yes.
Now,
Report of committee.
my lords, an internal committee was constituted under the chairmanship of she so-and-so, Joint Secretary so-and-so, and so-and-so to look into the recent recruitment process in Nectar of the following posts. After going through the facts and circumstances, committee makes these observations. It does not say, my lords, why this committee came about to be in the first place. There must have been something amiss somewhere, why this committee has to come into place after approval is granted.
Yes.
Now, this is one aspect of the matter, my lords.
Yes.
The other aspect of the matter is, my lords, the admitted position is that there is a recruitment.
Yes.
The recruitment culminates into an offer or an appointment, my lords.
Acceptance and appointment.
Acceptance, and I join the post. Now, once I join the post, my lords, the safeguards of Article 311 come into play insofar as I am concerned.
Right. Right.
So, to bypass, my lords, the protection of Article 301, whether a decision can be taken to undo the entire selection process, and if at all also, my lords, whether the protection of 301 can be waived. This is a question I ask myself, my lords, and your Lordships are aware that it is answered in a tenor of decisions that it cannot be done. Once you have issued the order of appointment, my lords, and I have joined against the said post, a vested right is created in my favor. So then you cannot take a U-turn and say that, no, we're going to do away with the entire selection process. Which is why I took your Lordships to page 156, which is my termination letter. Because your Lordships will kindly see the heading of that letter, my lords. It says cancellation of appointment.
Yes.
So they agree, my lords,
noted
there is an appointment, they're cancelling it.
Yes, I've noted that. Cancellation of appointment. Yes.
So in my humble submission, my lords, this itself at the
There's not
threshold,
a
my
recall
lords,
of offer letter or something.
Lordships, it goes to the root of the entire matter. Once I have joined, there's a vested right created on me, which cannot be undone in any other manner save by authority of law. And other aspects, my learned senior has already covered, my lords, that once approval is granted,
Yes.
in the same breath you say that we adopt the resolutions of the 8th meeting, and in any other matter, my lords, then you say that, oh, no, we're going to do away with the selection process. In my humble submission, my lords, that is not permissible in law. Now, the only other issue, my lords, that I would be required to answer to your Lordships is the issue of that Simon Foucault, who was part of that screening committee. Now, there are two aspects of the matter, my lords. He was already...
WPC?
My lords, Simon Foucault, WPC? WPC 433 of 2020.
1 second. 433 of
2022, my lords. The allegation is, my lords, that he was part of the screening committee.
Yes.
Now, there are two factual aspects in that matter. Let's just take out the relevant portions of the paragraph. Wait a second.
433. I quoted.
433, my lords. My lords, we are instructed on two aspects on this matter. A, my lords, he was only part of the screening committee insofar as sorting out the applications for the respective posts were concerned. That is the only job of the screening committee. They cannot take any decisions.
Yes.
The other thing is, my lords, what we are instructed is insofar as the petitioner in 433 is concerned, he was originally kept on wait list. He was not permitted to, my lords, sit for the examinations directly, the selection process directly. It is only after, my lords, there were no other applications received, then he was allowed to participate.
Has it come in affidavit?
It has not come on affidavit, my lords. I was just asking this. To that extent, my lords, we'll just point out the relevant portion. Where
Because that is it's quite vital anyway.
we'll bring it by way of an affidavit, my lords, because only to that limited extent, the records will speak for itself.
Okay.
But otherwise also, my lords, it will not have a material bearing. Even assuming, my lords, I was part of the screening committee, then also the protection of 311 comes in. Then also you had to hold an inquiry. You had to level an allegation against me, and then I had to be removed. Admitted position is, my lords, that none of that has been done. They take a unilateral decision one fine day that we're doing away with the selection process. That, my lord, in my humble submission, cannot be done. Coupled with the fact that you say that the advertisement is done away with, but certain people who have been appointed by that very same advertisement, my lords, you save them. And some other people, the petitioners...
Have you noted the other people who say about the advertisement also, or part of the advertisement is still continuing in service?
They are continuing in service.
Is there in the petition?
It is, I think in... excuse me, just ask ma'am. Ma'am, it's come in your rejoinder. No? They are still continuing in service.
No, rejoinder is it there? That these are the people who are appointed under the same advertisement, voted by which same
It has
advertisement.
come in one... Yes, yes.
Is there?
It has come in the rejoinder.
The appointment letter of the other.
That's all right then.
And yeah, one point also, I'd just like to bring to your lordship's notice. In that appointment letter, in clause 9, it is clearly written, otherwise also, that his or her services may be terminated by giving 3 months' notice by either side. No such 3 months' notice was also given to them.
Yes. Yes.
This entire exercise, my lords, otherwise cannot be countenanced in law. That's my humble submission.
No, it happens because sometimes when the people at the helm, they feel that it's done behind the back without them being given due importance.
Personal
So they try to
ego, my
undo.
lords.
It happens all the
My
time.
lords, this has already been brought to your lordship's kind notice. I must bring those general bylaws to your lordship's notice.
Yes, service bylaws.
No, not this, the other one. The one that you had given.
General bylaws.
General bylaws. Well, it's the one that your lordships were referring to earlier.
Yes.
This is the one, my lords, Northeastern Center for Technology and Application and Nectar, my lords. If your lordships kindly have bylaw number 9. This what had been argued before your lordships on the last occasion was that there was somebody else sitting as the chairman on that relevant day.
Yes.
And therefore this entire process was scrapped. The regular chairman was not there, somebody else was officiating on that particular day. If your lordships kindly have a look at bylaw number 9. It says, each member or his representative of the governing council and the governing council shall have 1 vote. And if there is an equality of votes on any question to be decided, the chairman shall have the casting vote.
Yes.
So once there is unilateral, my lords, approval by all the members, there was no question whether chairman is there or whether he is not there is irrelevant for the purposes of the appointment. So just to feed somebody's personal ego, my lords, the entire selection process cannot be done away with. I don't know if my learned friend will still argue that, but this is my answer in anticipation.
Yes, Dr. Mujka. Which one you argue first? Which would petition?
Rakesh Kumar, sir. The first one.
420.
Yes, sir. App number has been given, Melt.
Why have not? He has not indulged any cheating.
Primarily 2 aspects, my lord. My friend was referring to the previous General Council meeting resolution, my lord. At page 85 of the writ petition, my lord.
Yes.
My lord, as can be seen, what was the real purport of this resolution, my lord? The last paragraph it says, my lord, all the GC members endorsed their approval. Chairperson desired to place approval of GC before Secretary DST being chairman of Nectar. So, my lord, there is no final resolution taken in by way of this resolution, my lord. So, my lord, a half-cooked resolution that was taken, if that has been affirmed in the subsequent meeting, my lord,
Yes.
in my humble submission, there is nothing wrong with that, my lord.
You mean to say that he has a veto? Vote.
Exactly. That is
My lord,
He
it's
does
not,
not enjoy a veto power.
my lord, the members themselves say, my lord, we will place it before the secretary, my lord.
Yes, no, endorse approval. Is that the please approval of GC secretary being chairman? Do you want to just show it to him?
Yes.
Is that a question for decision or for his other views? Is that but nowhere is reflected?
It says please.
It's
approve.
desired because desire to place approval doesn't mean that it's mandatory. Now, if your bylaw is mandate that that suppose your GC endorse approval and that's subject to further approval, then that's placed in that way. That it'll be placed before the chairman who accords final approval.
But my lord-
just he desired this chairperson desired.
But my lord, kindly see,
His desire will not make it into a rule.
my lord, kindly see, when any resolution is passed, my lord, this is resolved or this is adopted, my lord, even that, the fundamental words are not there in this resolution, my lord.
This is not the resolution. This one.
They are saying they're relying entirely on this resolution, my
It's
lord.
not a resolution. It's the endorsement.
My lord, endorsement is also by way of resolution, my lord. The governing council adopts the resolution or approves the resolution.
So
Or
just wording. You
decides
can't attribute any
Endorse the approval.
No, this is a desire to place approval. Why desire? Desire means what? Desire doesn't mean that it's mandatory. He just desired. Let us place it before Dr. Mojika for his perusal.
And my lord, in the next meeting that was approved, my lord. The desire was approved, my lord.
Desire, so chairperson desire to, chalo, place it. It's like that.
So, my lord, what is
Because you're the chairman, huh?
what is more important is, my lord,
More important is the
The
procedure
advertisement.
adopted by your respondent in going through the whole recruitment process. Whereas above board, nothing is wrong with it. The only thing which you say is from what the submissions that firstly you should have gone by deputation.
my lord. And there was no.
Can that be such
There
a
was no
disqualifying feature that if qualified candidates are appointed,
My
there's
lord,
no
because deputation is for a limited period, my 2 years deputation, 3 years
so that means you
deputation.
don't want to appoint anybody.
Because the whole idea was, my lord, if you don't get a deputation, only in that case, a regular appointment can be made, my lord. And this is what the committee found, my lord. There was absolutely no attempt to get any suitable persons on deputation, my lord. That is one aspect, my lord. Second aspect is the appointing authority. My friends have pointed out, my lord. My lord, an appointment will be done by the appointing authority, my lord. Now, it has not even reached that authority, my lord, and somebody subordinate to it issues an appointment orders, my lord. It's not a question of prior approval, my lord.
What do we have ex post facto approval?
My lord, even ex post facto approval has never been granted, my lord, by the committee. 8th and 9th governing council meeting resolution, there is no such approval by the even ex post facto, my lord, for that matter. And my lord, what is more, third aspect, my lord, we have not outrightly terminated them, my lord. We have said that we will re-advertise the post. We convert your appointment to contractual for the time being. You are free to apply fresh and pursuant to the fresh advertisement, my lord. So it's not that we have caused any kind of serious prejudice to them, my lord. We have not thrown them out.
What do you say? So you see the whole recruitment process has been vitiated.
My lord,
It is a vitiated process.
my lord, if
Vitiated
I'm,
by illegalities, which cannot be, condoned or which cannot be,
my lord, to be fair to all prospective applicants, my lord, maybe because the deputation was mentioned in the
But
beginning, my
advertisements
lord.
only advertised at time. All prospective interested people would have responded to advertisement.
But advertisement was for deputation, my lord. But I'll just point out the wording in
Let's see that
advertisement.
advertisement.
Page 32, my lord. Applicants are invited from eligible Indian nationals for filling up various regular posts on deputation, including short-term contract, oblique absorption, failing which by direct recruitment. Page 32. Against such advertisement, my lord, which first talks
You mean
about
to say the whole recruitment process contrived to favor these petitioners?
that is the finding, my lord, of the committee constitution, my lord.
Then who's the person responsible then for making this contrived selection according to you? How many people applied for these posts? What was the manner of selection? Only by interview?
Only interview, my lord. Application, scrutiny of application and interview. There was no written exam or anything.
There's no written exam.
No.
Have you made an allegation in the affidavit that, the statement that the whole thing is vitiated? Like it's stage mannered? If that's what you're advancing now. If in your meeting you say that all recruitment rules were followed, and your advertisement also gives you, so all these 8 posts have been filled up, scientific posts. And who are the others allowed to continue then on the basis of the same advertisement?
Well, that is different advertisement, my lord.
Same advertisement. Same advertisement.
Then you cannot have different standards.
My lord, this other appointment, my lord, this is dated 22nd March 2022. And the petitioners were in January 22, my lord.
No, but same advertisement.
Same advertisement.
My advertisement may be same, my lord, but it appears that this was placed in the governing council later on, my lord, and only after the approval of the governing council, the appointment letters were issued, my lord.
Just colon says in Thalai.
My lord.
Where is written that the governing board council approves the appointment before appointment orders were issued?
Your Lordship, kindly kindly have para 27 minutes. Second part of para 27 of the counter affidavit is how they have dealt with that particular case.
I mean, in their affidavit.
Yes, in the counter affidavit, minutes, para 27.
No.
No, 27 is it goes to cat.
I don't know if pages it is, paragraphs are different.
Which cases?
Oh no. 430 minutes. I'm sorry, in my petition. It brings out, my lords, why this entire thing has happened. That's why I pointed it out.
Which para in this one? In
Para
this 420?
27, page 15, my lords, if your lordships have.
How does this? No, I have this affidavit which pointed out there because I want to mix up these affidavits from all these files. Then
Para 15, my lords, page 15.
I'm looking at 420.
I'm sorry, my lords, 420. I don't know in 420. They must have stated the same in 420 also, my lords.
Now let's see the 430. No? 4.
430, my lords, if your lordships can have page.
Affidavit.
Para 27, page 15. What I had submitted it before your lordships of personal bias, my lords, that's the only reason. If your lordships kindly see the second para on page 15 minutes.
Yes.
It starts off, it is further denied
Yes.
that bias, arbitrary action, and malified intention of the respondent is writ large in the action inasmuch as to the knowledge of the writ petitioner. The respondents have not cancelled the appointment of the incumbent to the post of advisor technical, which post was also covered by the same advertisement, and the appointment letter was also issued by the Director General Nectar, and subsequently ex post facto approval was given by the Governing Council. It's the same ex post facto approval. It is pertinent to mention that the post of advisor technical approval was given by the General Council, and moreover, the Chairman Nectar was himself in the selection committee. So only because Chairman was in the selection committee, my lords, we don't need to touch it.
Yes. How do you meet that, Dr. Mazik? If you say that the whole section was vitiated, all appointments should go, even any given point of time.
Why do people? Just this point, what my learned friend was submitting that, Your Lordship, that the chairman desired to place approval of GC before Secretary DST. The chairman was not there in that particular meeting. Your Lordship will see in that 8th general body meeting, it is recorded that Chairman Nectar could not attend the meeting due to other important non-negotiable meeting and nominated Dr. Renu Sharma, Chief Secretary, Government of Mizoram, to preside over the meeting under proviso to Rule 14 of the Rules and Regulations of Nectar. That the rules provide that General Council is consisting of 10 members. So all the 10 members were present. And the Rule 14 provides a person holding the membership of the Executive Council by virtue of an office held by him shall normally attend the meeting himself in person, but in exceptional circumstances shall have the right to nominate a representative to act on his behalf at a particular meeting, and the representative so nominated shall be entitled to take part in the proceedings of that meeting. The representative shall also have the voting right of the member. So it is as good as the chairman himself because he has nominated, and
Happens like that
the
only.
authority power is given.
No, that's why desire. Why desire?
only
The very
desire.
fact, no, the very fact desire is there is that, look, since chairman could not attend
So
the
it
meeting,
cannot
at
be
least
said that
that's
it
a
is
mark of
after-
respect and courtesy. Place it before him also, that's all.
That's all.
He's not part of the meeting, he's not part of the meeting. Suppose the president is not present, the vice president presides, and the minutes are generated, resolutions are taken up. Doesn't mean that the president, he's there one fine day, you just show to the president, just that.
And out of all this,
Any other submissions to make, Dr. Mozika? Any authorities?
now why they have selected to give approval of general counsel only for one single post?
That
Same
that
selection.
works against them.
Pick and choose one person to protect him, and others just scrap their appointment.
On that particular appointment, I don't have a proper disseminate whether that has been interfered with or not interfered
But you
with.
want to adjourn the matter again?
I don't want to adjourn, my lord, but without reference to that, my lord, because that is, I have not been able to counter that. Whether his appointment still subsists or it has been interfered with, first aspect, my lord, and whether governing council's approval was there or not,
Or whether his appointment is converted to contractual?
my lord.
You don't know.
I don't know.
Or if you give you bullet points, then since you want to reply, a little bit reply. Otherwise, we'll close it.
Yes,
We'll close it.
I'll give it bullet points. My lord.
Yes.
And on that, if I get something, my lord,
Yeah, then you can just add it there. Otherwise, summon substance, I think, illegality is writ large because once you appoint, but only point is argued is that whether the High Court is the correct forum or not.
Yes,
If
it
these-
is not covered under statutory.
It's not covered like that. It's not there in the thing.
No, that
Nectar is a new thing also, so you don't have it. No corrigendum, addendum, right, to that list.
As of now, no, my lords.
And it is the general counsel, otherwise also is the supreme. Secretary DST again do not exercise any exceptional or
Give you authorities.
special power
Yes.
to direct that it
You
should
give
be
bullet
scrapped.
points anyway, like we'll fix, just for fixing, for filing bullet points. We'll list it on next Friday for filing bullet points. That's it. And don't delay, huh?
so I will file.
Telling her. Because she's the last resort for a chamber. She comes and, when others don't succeed, she comes and seeks adjournment.
She has to take the burden.
She takes, the buck stops with her, I see. Thank you.